the tail coverage bill in OBGYN, and why it arrives at the worst possible moment. Most OBGYN contracts say malpractice insurance is provided. That sentence sounds like the issue is resolved. It is not. The question is what type of coverage is provided, who owns the tail when you leave, and what the tail actually costs for a specialty where claims can arrive a decade after the event. There are two types of malpractice policies. Occurrence-based coverage protects any event that occurred during your coverage period, regardless of when the claim is filed. A complication from a delivery in year 2 of your employment is covered even if the claim arrives in year 8. Occurrence policies follow the event. Claims-made coverage protects only claims filed while the policy is active. The day your employment ends is the day the coverage ends, unless you purchase tail coverage separately. Any claim filed after your last day of employment is unprotected. Most hospital-employed OBGYN physicians carry claims-made policies. The malpractice clause in a typical OBGYN offer letter does not specify which type. Most physicians do not ask until they are leaving. Here is the OBGYN specific problem. Obstetric claims have a uniquely long statute of limitations. In most states, a birth injury claim can be filed through the child's 18th birthday, in some states longer. An OBGYN physician who spent 5 years in a claims-made position and leaves has 5 years of deliveries, surgeries, and gynecologic procedures potentially exposed without tail protection. Tail coverage for an OBGYN physician with an active obstetrics practice is not the $5,000 to $15,000 range that applies to a primary care physician. Industry estimates place OBGYN tail coverage in the range of $30,000 to $75,000 or more as a one-time purchase, depending on state, prior acts coverage period, policy limits, and whether the practice included high-risk obstetrics. That bill arrives on the day you resign or are terminated, which is also the day you are least prepared to absorb an unbudgeted 5-figure or 6-figure expense. Two things to clarify before you sign. First, who is responsible for tail coverage upon separation? The contract clause can assign responsibility to the employer, to the physician, or split it based on the reason for separation. Termination without cause by the employer often creates an employer obligation to pay tail. Voluntary resignation typically does not. That distinction is worth tens of thousands of dollars. Second, does your incoming employer offer nose coverage? Retroactive protection for prior acts? If yes, your tail exposure at departure drops significantly. Ask specifically about nose coverage before assuming you need to purchase a tail independently. OBGYN has the longest malpractice exposure window of any outpatient specialty. Tail coverage is not a line item footnote. It is a financial event that the contract language either protects you from or assigns to you. Run your contract through ClauseLine at ClauseLine.com.